Julie. And I'm delighted to be back here with you. I see some familiar faces in the crowd, and I'm looking forward to your questions. So let me start by saying that the recent term of the Supreme Court, the one that ended in July, was marked by huge victories for conservative positions, but the court's decisions also reveal an institution that is deeply divided and I think struggling somewhat to do its work. Before we look at the specific cases, the important ones from the last term, I'd like to take a few minutes to reflect on the court itself, because I believe, I hope you'll agree, that this perspective will be helpful as we look at specific cases later on. And then after that, I'll cover the situation with the court's current term that started in October. But I'd like to cover 6 aspects of the court's work. First, Chief Justice Roberts' leadership. Second, conflicts among the justices. Third, the impact of fractured majorities. 4, is the court doing its job? 5, ethics issues and calls for reform. And then 6, Justice Barrett's voice. So let's start with Chief Justice Roberts. Well, you can emphatically say that he is in charge of this court. He was in the majority 96% of the time during the last term, but more importantly, he wrote the opinions in many of the most significant cases. Now, in previous court terms, he's taken a more incremental approach, possibly an institutionalist approach, and he's somewhat times been criticized for the slowness of his embrace of conservative positions. But this term, he seemed to be out in front. And the result was major victories for conservative causes and very few significant wins for progressive causes. But on September 15th, we received a surprise confirmation of Chief Justice Roberts' control over the court, because the New York Times published an article by reporters Jody Cantor and Adam Liptak that details how the Chief Justice propelled the court to issue significant decisions in favor of President-elect Trump in the Colorado ballot case, the presidential immunity decision, and the scope of the federal criminal statute that's used to prosecute January 6th defendants. In connection with the presidential immunity case, this article reports that although the liberal justices indicated a willingness to join the majority opinion by agreeing with some of the points in exchange for a moderation of the court's position in other points, the Chief Justice simply froze them out. The article also cites an internal memo written by the Chief Justice dated February 22nd, which was days after the court had taken the presidential immunity case. And in the memo, the Chief Justice harshly criticizes the lower court's decision and states, "I think it likely that we will review the separation of powers analysis differently," meaning differently from the appeals court, but showing that he was already working at that point on leading the court to a certain conclusion as soon as the court took on the presidential immunity case. Well, while this information about the inner workings of the court in this case and the influence of the Chief Justice, it's very surprising and concerning. But for me, the startling, I could even say shocking thing about the article in the New York Times is the extent to which it is based on conversations with unnamed court insiders who gave the New York Times reporters lots of information about what are usually carefully and closely guarded internal deliberations. Normally, we wait for decades for some retired justice to publish a memoir that tells us about the inner workings of the court 20 or 30 years earlier. Also, the information in the article clearly suggests a degree of disarray and dissent within the court that is very concerning. Again, the article appeared in the New York Times on September 15th. There's lots more detail than I was able to give, so if you want to check it out, the authors are Jody Cantor and Adam Liptak. Well, let's turn to what about conflicts among the justices. Justice Oliver Wendell Holmes once described the court as 9 scorpions in a bottle. Well, Dean Erwin Chemerinsky of UC Berkeley Law School recently updated that image to 9 angry scorpions in a bottle. This term, the court decided 59 cases, of which almost half were decided in split decisions 6-3 or 5-4. But even in unanimous cases, there was a large number of opinions, and we'll come back to the significance of that in a few minutes. But here are some examples of strained relationships among the justices. It is court tradition that when dissenting, a justice begins with, "I respectfully dissent." However, Justices Sotomayor and Jackson omitted the respect in significant cases this term. For example, in the presidential immunity case, Justice Sotomayor started her dissent with the phrase, "With fear for our democracy, I dissent." On the other hand, in the Colorado ballot case, Justice Barrett criticized the liberal justices' concurrence by noting, "This is not the time to amplify disagreement with stridency." This court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstance, writings on the court should turn the national temperature down, not up. Well, let's come back to this issue of the impact of fractured majorities, because court observers noted that this term produced a large number of concurring opinions. For example, in Rahimi, the case involving the question of whether a man subject to a domestic relations restraining order may possess a gun, in that case, there were 7 opinions, including 5 separate concurrences. So what's the significance of this? Well, these concurrences don't change the outcome of a case. They simply offer the viewpoint of an individual justice that failed to gain the support of a majority of the justices. So they can cause confusion, especially among lower courts, as judges seek to apply the court's pronouncements to in different situations. I found one law review article that described concurring opinions as a latent form of judicial activism. Justice Thomas is particularly known for using his concurrences to send messages about what cases he thinks litigants should try to bring to the court. But in perhaps an extreme example of the power of a concurring opinion, on July 14th, Judge Eileen Cannon, the district court judge handling the Trump documents case, dismissed the case, stating that the special prosecutor was unconstitutionally appointed. Well, her opinion cited and relied upon Justice Thomas's concurring opinion in the presidential immunity case, although no other justice, let alone 4 other justices, had joined in that opinion. So that leads me to the next topic: is the court doing its job? Well, on a couple of measurements, one can argue they're not doing a particularly good job. I noted earlier that this court decided 59 cases during the past term. In the 1980s, the court decided as many as 160 cases per term. Now, this number has been steadily declining since then, but as recently as 20 years ago, the court decided 85 cases. This term is pretty much in line with the court's performance in its most recent terms. So arguably, the court's been doing less work or working more slowly than earlier courts. But on another measure, and perhaps a more important one, I think the court may be failing. I view the court's most important job as being able to decide cases in a way that provides principles to help lower courts decide cases involving similar issues. Many of this term's decisions reflect what I call judicial kicking the can down the road, as the principles announced by the court are incomplete or vague or unintelligible, meaning that future cases will have to come back to the court itself for further interpretation. The presidential immunity case is a clear example of this, as is the 2022 Second Amendment decision in the Bruen case involving gun rights. So I'll mention that a little more later. In addition, those fractured majority decisions involving a lot of concurring opinions, they also sow confusion and lack guidance for the lower courts. So where does this all lead? Well, right now, fewer than half of Americans express a favorable opinion of the court, and this is close to a 3-decade low. Now, I have to pause here and say, what is the problem with this? Does it matter? I say it does, because keep in mind that in our system of government we have three branches of government. The Congress has the ability to tax, the administration, the executive has the ability to deploy troops, and the court has no enforcement ability whatsoever. So all it takes, if the court issues a ruling that some governor and attorney general think is bogus, they can simply say, we're not going to follow it. And that's a mini constitutional crisis in the making. So I'm not sure that we're very far away from that today, and that's what worries me about the public perception of the court, because all it has to rely on is the fact that it's held in the esteem of the public and that the public will follow its decisions. Well, each year I know I have to put the ethics question on in my remarks about the court, but quite frankly, I'm getting a little weary of that. You may recall that last year the court announced an ethics code, which I think I described as window dressing, mainly because it has no enforcement provision to it. Well, and no surprise, it doesn't seem to have had much of an impact. But any congressional legislation to impose a more stringent code of ethics on the justices would be dead on arrival in Congress. While Justice Sotomayor recently suggested that the court itself could consider a more stringent ethics code, I think it's unlikely that she will be able to persuade a majority of her colleagues to join her. And the same goes for proposals for reforming the court. 78% of the public support term limits. That's an amazing statistic, and I think that would be an excellent improvement. But again, it will not get anywhere in this Congress with this situation on the court. And now for the final topic before we go on to the major decisions. Many court observers have said that this term, Justice Barrett, emerged as a principled voice on the court. Let me give you a couple of examples. I mentioned earlier her opinion in the Colorado ballot case chastising the liberal justices for sending a divisive message. Second, in the presidential immunity case, her concurrence criticized the most controversial part of the majority's ruling, and we'll come back to this later. I found a New York Times article on July 8th by Stephen Vladeck, who's a law professor at Georgetown, and he calls out 8 instances and where Justice Barrett comes across in her writings as what he calls principled, nuanced, and fair-minded. So it remains to be seen whether in future terms her conservative colleagues will pay more attention. So now let's turn to the major decisions of the 2023 term, and we'll start with the big ones, the 2 Trump cases. The presidential immunity case was a 6-3 decision written by Chief Justice Roberts, and the court held that the president is absolutely immune from prosecution for acts taken in furtherance of the core duties of the office. In addition, there's qualified immunity for actions involving the outer perimeter of the president's duties. And in this outer perimeter area, a president can be prosecuted if the government can show that prosecution would pose no dangers of intrusion on the authority and functions of the executive branch. Well, that's an extremely fact-specific determination, and the court offered no guidance as to lower courts as to how to apply it. While immunity does not apply to private actions, the court held that evidence involving actions taken in furtherance of presidential duties may not be heard by a jury in a private action. Now, this is the issue that is involved in the Trump New York case because the defense claims that some evidence introduced by the prosecution pertain to official presidential acts. The judge in the New York case was expected to rule on the issue on November 19th and then extended that to for another week. So we still don't know how he's going to handle this case. This last point involving private actions is the one that I mentioned earlier that Justice Barrett took exception to. Well, this is one of those cases where the questions left unresolved make it inevitable that future cases will have to be decided by the court. For example, what are official acts and what are core constitutional powers versus outer perimeter powers? Justice Jackson noted in her dissent, the court today transfers from the political branches to itself the power to decide when the president can be held accountable. I call that judicial activism. Well, here's an interesting side observation. Since President-elect Trump has promised to prosecute his predecessor, we may see the court resolving these open issues in a case titled U.S. v. Biden. Okay, let's go on to the second case, the Colorado ballot access case. This was a 9-0 decision holding that Congress, not the states, has the authority to enforce Section 3 of the 14th Amendment. And you'll recall this is the section that provides that an individual who's taken an oath to support the Constitution and then engaged in insurrection or rebellion may not hold office in the United States. Well, the decision gave no guidance as to how Congress is to exercise that authority. Of interest is the speed with which the court took action. They accepted the case on January 4th. Oral argument took place on February 8th, and the decision was announced on March 4th. for the Supreme Court, that is a whirlwind of action. Now let's turn to the topic of gun rights. The court addressed 2 gun rights cases this term. In U.S. v. Rahimi, the court ruled 8-1 in an opinion by Chief Justice Roberts that when an individual has been found to be a credible threat to the physical safety of another person, such as being the subject of a domestic relations restraining order, that person may be disarmed consistent with the Second Amendment. I mentioned earlier the court's Bruen decision in its 2021 term. Well, that decision established a sweeping expansion of gun rights by striking down New York's concealed carry law. And Bruen was based on an originalist analysis of the Second Amendment, meaning that courts were directed to apply the decision by looking at the history and tradition in the United States when the Constitution was adopted. And Rahimi was the first time since Bruen that the court addressed the Second Amendment. Interestingly, they found an exception to Bruen in this case, disarming Mr. Rahimi, even though I'm pretty sure that there was no such thing as domestic violence or restraining orders prevalent in the late 18th century. This case produced one of those fractured majorities that I described earlier. There were 5 concurring opinions, and Justice Thomas dissented, saying that he could find no exception to Bruen here. But the concurring opinions by Justices Gorsuch, Kavanaugh, and Barrett illustrate those justices' different approaches to an understanding of originalist principles. I am not recommending them for light bedtime reading. But we can expect more gun rights cases to come to the court in the future as lower courts are struggling to apply the Bruen decision. For example, a district court judge in Kansas recently held that laws prohibiting possession of dangerous weapons such as machine guns, that those laws are invalid under Bruen. The second gun case, called Garland v. Cargill, represented a challenge to a Bureau of Alcohol, Tobacco, Firearms, and Explosives regulation, which banned the sale of bump stocks promulgated during the Trump administration. Now, a bump stock is a device that permits an automatic weapon to be modified so that it will fire repeatedly in a manner similar to a machine gun. And this was a 6-3 decision split along partisan lines, and the court held that the Bureau exceeded its authority by classifying a bump stock as a machine gun. The next topic on my list is abortion. Well, 2 cases involving abortion came to the court this term, and neither resulted in a substantive ruling. The first case, the abortion pill case, involved an attempt to severely curb nationwide access to mifepristone. This was a 9-0 decision, and the court held that the plaintiffs who brought the case had not suffered an injury that would be redressed by banning the abortion pill. So the decision really does nothing to address the question of the validity of restrictions on the pill in the states with near total abortion bans. The second case, called Moyle v. United States, also resulted in no substantive guidance, as the court merely dismissed the case as certiorari improvidently granted. You could say that the translation of that is we goofed, or we took it too soon, or something like that. At issue in this case was a conflict between a federal law and the Idaho abortion law. Now, the federal law is called the Emergency Medical Treatment and Labor Act, and it's known as EMTALA, and it requires Medicare-funded hospitals to provide essential care to patients experiencing medical emergencies. The Idaho law prohibits abortions unless necessary to prevent a pregnant woman's death. So these two laws were in conflict. The court decided not to make a decision, so for now that means that the lower court decision, which allowed for emergency abortions and blocked enforcement of the Idaho law, that will stand. However, on the first day of the new term, this October, the court issued a ruling declining to get involved in a similar case coming from Texas. But there, the lower court had held that the Texas abortion law trumps EMTALA. So we have the situation where EMTALA governs in emergency situations in Idaho, but not in Texas. That's not a very attractive situation, and I expect that this issue will return to the court in the future. The next topic I want to go into is the powers of federal agencies. And the court addressed several issues involving federal agencies, which generally resulted in a curtailment of agency power, with one exception. The most publicized case is called Loper Bright Enterprises v. Raimondo, and in it the court held 6-3, divided along ideological lines, in an opinion by Chief Justice Roberts, that courts do not need to defer to federal agencies' interpretations of ambiguous statutes. In other words, the court held that federal courts can interpret ambiguous statutes. To reach this result, the court overturned a 1984 precedent called Chevron v. National Resources Defense Council, which had previously been relied on by the court almost 70 times. So this decision, as I said, shifts power to the judiciary, which now will be responsible for interpreting ambiguous statutes. And to some extent, it also puts pressure on Congress to amend existing ambiguous statutes and maybe to try to avoid ambiguity in further legislation, but I think that's probably an impractical goal as a practical matter. A second blow to administrative agencies came in the case called SEC versus Jarkissi. And in it, the court ruled in a 6-3 decision, divided along ideological lines, opinion by Chief Justice Roberts, that the SEC's own administrative courts that adjudicate civil penalty cases under the securities laws violates the 7th Amendment right to a jury trial in civil cases. Now, this decision calls into question the validity of internal administrative courts proceedings in many other federal agencies. Justice Sotomayor's dissent suggests that the terms of about 200 federal statutes provide agencies with the authority to impose civil penalties. Then the third case is called Corner Post v. Federal Reserve. It's a 6-3 decision. It's written by Justice Barrett. And in it, the court held that the 6-year statute of limitations for bringing an action to challenge an agency's regulations begins to run when the plaintiff is injured by a federal agency regulation, not when the regulation was originally enacted or promulgated. So we have a situation where this vastly expands the period of time when agency regulations may be transferred or may be challenged. So taken together, these three cases, Loper Bright, Jarkissi, and Corner Post, have created a surge of litigation against the power of the federal bureaucracy implementing these decisions. And then finally, in the only win for a federal agency this term, the court held that the way the Consumer Financial Protection Bureau is funded does not violate the appropriations clause of the Constitution. This was a 7-2 decision. There were 2 concurring opinions, and Justices Alito and Gorsuch dissented. A contrary decision would have called into question every single regulation and enforcement action the Bureau took over the last 12 years since it was created. And that involves such huge topics as mortgages, credit cards, consumer loans, and banking. My next topic is voting rights. In the past, the court has refused to get involved in adjudicating cases involving political gerrymandering, whereas it has looked at cases involving racial gerrymandering, such as the one in the 2022 term involving the congressional districts of Alabama. The case in the most recent term is called Alexander v. South Carolina State Conference of the NAACP, and it raised the question how courts should distinguish between redistricting by race and redistricting by party affiliation, when, as we know, there can be very close correlations between the two. This was a 6-3 decision, and the court divided along partisan lines. So the court allowed South Carolina to continue using, for the 2024 election, the congressional district map, which had been found by the lower court to be an unconstitutional racial gerrymander. Now, the court's opinion noted that inferring bad faith based on the racial effects, emphasize effects, of a political gerrymander in a jurisdiction in which race and partisan preference are very closely related, that inferring them based on the effects would allow litigants to get around the court's precedent that courts should not consider political gerrymandering cases. But the result is that this decision makes it very, very difficult to challenge any map as racial gerrymandering, as long as the lawmakers claim that their goal in drawing the map was to simply secure a political advantage. But then, on November 4th, the court added to its docket a challenge to the Louisiana congressional district map that includes 2 black districts. So later this term, we will see where the court takes the issue of racial gerrymandering. But meanwhile, the challenge map was used for the November 5th election. Let's turn to criminal law. The court issued 2 significant criminal law decisions. The first is Fisher v. U.S., and in it, the court narrowly interpreted the federal criminal law statute used to convict participants in the January 6th attack on the Capitol. The decision was 6-3, and Chief Justice Roberts wrote the majority opinion. Now, in reaching this result, the court applied a textualist approach. It looked at the statute, and the statute says that a violation exists if the defendant impaired the integrity or availability for use in an official proceeding of records, documents, objects, or the like. And so the court concluded that since there were no records, documents, etc., that this statute did not apply. So the decision potentially affects the federal case against any of the January 6th participants. But in most instances, the ruling will have a limited effect since these charged individuals have been indicted under several other criminal statutes. One report I read indicated that of the 1,417 people charged in connection with January 6th, only 26 defendants pled guilty fealty exclusively to the statute in question. And in each case of those 26 individuals, the plea agreement specifically provided that the plea would still stand even if the statute were interpreted not to apply to the January 6th events. The second criminal law case is City of Grants Pass v. Johnson. The court decided 6-3 along ideological lines that the enforcement of generally applicable laws regulating camping on public property does not constitute cruel and unusual punishment prohibited by the Eighth Amendment. Justice Sotomayor's dissent, joined by Justices Kagan and Jackson, argues that punishing people for being homeless and needing to sleep in public is unconscionable and unconstitutional under the Eighth Amendment. Okay, finally we come to the topic of the First Amendment and free speech. The court decided a number of cases involving free speech issues, and I'm going to highlight just a couple of them. The first is actually two cases haired together. It involved decisions by the Fifth and the 11th Circuits about the extent to which states may pass laws that regulate the content of social media or that restrict the ability of social media companies to moderate content on their programs, on their platforms. This was a 9-0 decision, and the court simply sent both of these cases back to the lower courts, directing them to perform a more complete First Amendment analysis of the issues. This was another one of those fractured opinions. Justice Kagan delivered the opinion of the court in which Chief Justice Roberts and Justices Sotomayor, Kavanaugh, and Barrett joined in full. So far, so good. 5 justices agreed. But bear with me for a minute. Justice Jackson joined only as to parts 1, 2, and 3A of the opinion. And Justice Barrett filed a concurring opinion, and Justice Jackson filed an opinion concurring in part and concurring in the judgment. Justice Alito filed an opinion concurring in the judgment, in which Justices Thomas and Gorsuch joined. What a mouthful. Well, all I can say is you can bet that the lawyers on both sides of both of these cases will be studying every single one of these opinions carefully as they prepare to rebrief and re-argue these cases in the lower courts. And then finally, Murphy versus Missouri is a 6-3 decision in which Chief Justice Roberts and Justices Kavanaugh and Barrett joined the liberal justices, and it gave the Biden administration a practical victory by rejecting challenges to its practice of contacting social media platforms to combat what they perceived as misinformation. But the basis of the court's decision was standing. They held that neither the individual plaintiffs nor the state plaintiffs had established the right to seek an injunction. So I think we can expect this issue to return to the court in the future. Well, let me summarize in a few words, the previous term. Number one, significant victories for President-elect Trump in the presidential immunity, the Colorado ballot, and the January 6th prosecutions. Number two, the court is clearly struggling with the consequences of its Bruen gun rights decision. Number three, no substantive progress on abortion rulings. The court thought it was turning that mess over to the states, but it keeps coming back. Number four, conservative victories against federal administrative agencies, overturning the Chevron docket, jury trial required in federal agency proceedings, and expansion of the statute of limitations. Number five, huge loss for progressives in the voting rights decision. And number six, a modest Biden administration wins in the social media and the Consumer Financial Protection Bureau case. So let's turn to what about the current term? What should we look for? Well, so far the court has placed about 47 cases on its docket for oral argument, and it will add more in the next few months. By the way, it just announced that it will start issuing decisions on November 22nd. So that's pretty quickly. They only heard the oral arguments in October. My guess is it will be some insignificant, from our perspective, case that is actually decided on November 22nd. Now, before the election, some commentators observed that the docket appeared to be sleepy, meaning that, or suggesting that possibly the court was expecting to receive cases stemming from the November election and was leaving room on its docket for that purpose. In fact, the court had already been involved in several election-related cases which were resolved on the emergency docket during the week before the election, including issues coming out of Virginia and Pennsylvania. And I just wanted to note here that it seems that when the court is handling these types of voting issues on the emergency docket, the court tends to rule in favor of the positions of state election officials and rejecting challenges to the position of state election officials. And I noticed that the court followed this approach also a few years ago when it was dealing with the changes in election procedures that were caused by the pandemic. Well, given the decisive result of the election, it seems there won't be the number of cases previously expected. So let me just mention a few significant non-election cases that are now on the docket. Glossop v. Oklahoma is a complicated death penalty case involving suppression of evidence. Now, the Oklahoma Attorney General has announced that there was an error in the trial and has recommended a new trial, but the Oklahoma Court of Criminal Appeals has refused to stop the execution. This case was argued on October 9th, and based on the oral argument, some observers have predicted that the court will not rule in favor of Mr. Glossop. But I need to emphasize that there has been no decision yet. It's only been the oral argument, so it's early days. The second case is called U.S. v. Skermeti, and it involves a challenge to a Tennessee law prohibiting transgender medical treatments for minors. Oral argument is scheduled for December 4th, and the new Trump administration may actually decide to change course on this case and withdraw the government support. So that might stall the case for a while. Another case is called Garland v. Vanderstock, and it raises the question whether ghost guns are subject to federal licensing and background check and so forth requirements. Now, ghost guns have no serial numbers. They can be assembled from parts, usually purchased as a kit, usually on the internet. The oral argument took place on October 8th, and some observers have predicted a victory for the government upholding the regulations, but there has been no decision yet. Again, the Trump administration could reverse course on this simply by rescinding the regulation in question. Free Speech Coalition v. Paxton is a challenge to a Texas law that restricts minors' access to pornography sites, and the oral argument is set for January 15th. Barnes v. Felix raises the question whether courts that are deciding police excessive force cases should look only at the narrow window of time when the police officer's safety was threatened to determine whether the officer's actions were reasonable. And that will be argued on January 22nd. And then finally, the challenge to Louisiana's redistricting that I mentioned earlier is called Louisiana v. Calais. It has not yet been set for oral argument. Well, I know you're all wanting me to tell you what I think the effect of the election will be on the court. So let me give you a few numbers. 76, 74, 70, 69, 64, 59, 57, 54, 52. You know what this is? The ages of the 9 sitting justices. So Justice Thomas is 76. He's been on the court for 33 years. Justice Alito is 74. He's been on for 18 years. Justice Sotomayor is 70. She's been on for 15 years. Chief Justice Roberts is 69, and he's been on for 19 years. Well, I see 3 possibilities involving the court. Number 1 is the obvious one. Either Justice Thomas and or Justice Alito could step down to make way for a younger Republican conservative justice. Although I've heard that Justice Thomas wants to stay on the court long enough to become the longest sitting justice. Now that what would you call it, record is currently set by William O. Douglas, who served for 36 years, 7 months, and 8 days. For Justice Thomas to exceed that would take him well into 2028, which might be a risky time to try to replace him. So we'll see. Second speculation. Justice Sotomayor's health is not the best, and so the possibility exists that she would have to step down sometime during the Trump administration, and a Republican would be appointed, resulting in a 7-2 supermajority. And then the third possibility, I think, is pretty extreme, but Chief Justice Roberts has been criticized for some of his earlier votes against conservative causes. Now, he's also well known for many of his decisions in favor of conservative causes, but President-elect Trump has referred to Chief Justice as an absolute disaster. So there's a possibility that there will be pressure on him to resign because of earlier votes against the conservative causes. So that brings me to the end of my prepared remarks, and I'm looking forward to your questions, and I'm wondering if I might be permitted to sit down while we talk about the questions. Would that be okay?